Viewers, welcome back to the Personal Injury Law Show. Before the break, we were talking about the life experiences of Wayne Crockford, and now it's time for Kathy's mailbag. Kathy, what did you think of that?
Oh, good evening, Tony, John. That's right, good evening, viewers. Tony, I actually thought it was a really, really good segment. It was also nice to actually hear someone's story and someone that's actually gone through it. As it's
pretty
different
compelling, wasn't it?
Absolutely, and it's always different from a legal perspective and from someone's actually going through the pain and suffering. And I have to actually commend you on your work for that case as well. So well done, congratulations.
It was a team effort, like I said. Jade was involved. Jade's another lawyer in the law firm, so for people that don't know who she is. But John, it was a very quick process. It settled very quick, didn't it?
I'm astonished that WorkCover came to the party on that one, Tony.
As quickly as they did.
Yes.
Yeah. It was just surprising that it happened in 2009. We're only in 2011 and the matter's resolved.
Unfortunately, viewers, it doesn't occur all the time. That's the problem.
And the thing about him is that, as you can see, he's a knockabout sort of a guy. And if it had gone for longer, he would have been very depressed.
Exactly.
Yeah. And he'd already started getting psych issues.
Exactly.
Well, everything is on a case-by-case basis. But, Tony, I have to stop you there. It was very nice having Wayne on board, but we need to get to the viewers' questions, as it is that segment. Question 1 comes from Fred in Melbourne, and he writes, Dear PI Show, I'm 20 and work for a furniture removalist company. I was recently injured when working in an open cage moving workstations, a job that is ordinarily for 2 people. I asked for assistance with this job, but nobody replied, and my boss told me to carry on. Whilst attempting to move the workstation, I dropped it, which left my left knee crushed, resulting in a dislocated injury that tore my quad and has damaged tendons, ligaments, and cartilage. I feel really put out and sad because I might not be able to follow my career path and join back up with the police force. Thanks. And that's from Fred. John, how can you answer Fred's question?
Fred, you've got significant WorkCover entitlements, it seems. You should be lodging a WorkCover claim. It sounds like you can't work at the moment because of your crushed left knee, so you're entitled to weekly payments of compensation, medical and like expenses, and thereafter, it sounds like with a crushed left knee, you've got significant lump sum entitlements, including a permanent impairment benefit and your common law damages claim. Negligence, Tony, seemed pretty good on that too.
Seems pretty good. The only thing that concerns me is his age. He's only 20.
Well, he's 20, but a significant knee injury, as you know, footballers at times can never play again.
The only reference I made to his age was in relation to loss of income.
Yeah.
And the 40% test doesn't apply, John, because he's under the age of 26.
Exactly.
And what does it mean, the 40% test?
Well, Tony, under the law of Victoria, for economic loss claims, you must show that you've lost 40% or more of your pre-injury earning capacity.
And so because he's 20, you don't have to do that, do you?
Exactly.
Yeah, and you can look at what he wanted to do in the future. So instead of being confined to his income as at that time, you can look at to see what he could have earned in the future in his job in a police force.
Exactly.
I don't know what police officers earn, but you'd think they'd be on 60 plus, wouldn't they?
Oh, it's a significant, it'll be significant earning capacity that's been damaged here, Tony, because being in the police force, he has to run around, he has to walk around. He might not be able to do that now.
I couldn't see him dashing around in a hurry because he's got, not only has he crushed a knee,
exactly,
he's torn quads, but he's damaged tendons, ligaments, cartilage.
Exactly.
So it's a progressive injury.
And the pivotal part of the claim is the fact that he's requested assistance. It's a job for 2 people, not 1, and yet the employer has ignored him.
John, the fact that he's asked for assistance, does that mean that he's contributed to his injuries by doing the job? Should he have said to the employer, I don't want to do it?
No, Tony.
Can't say that?
Well, he doesn't want to lose his job, Tony. I mean...
Well, that's a good point.
He wants to work, he wants to earn a living. Now, he's trying to do the right thing by the employer. They're not doing the right thing by him.
So, Kathy, that was a good point made by John. You shouldn't punish a worker for carrying out his duties, notwithstanding the fact that he thinks that it's unsafe.
Well, you're supposed to actually help the worker in carrying out those duties, and it's a responsibility of the employer in trying to find mechanisms to assist in that way.
But how many times has a lawyer working for WorkCover said to me, your client shouldn't have done the job if he needed assistance? He's already identified a problem. Why is he doing it?
But what about if the employer then fires the employee
for
not performing the duty?
And not only that, he knows the risks involved and he's trying to do it to the best of his ability and the safest way he can. So he shouldn't be punished by that.
I think it's a very sad
But they
case
have
for
raised it quite a
Fred.
bit in the past.
They always raise it.
And they've tried
It's-
to reduce damages by way of contributory negligence.
It's very unfair, Tony, isn't it?
It's not a very nice. It's a very sad case for Fred, given that he wants to also join the police force.
Well,
as well.
Fred, you
Get a
need
lawyer.
to see a lawyer because you've got a significant work cover claim.
I agree with that, John.
Okay, thanks for writing in, Fred. Moving on. Hi, guys. Last year, my wife rolled her ankle while on yard duty at work. Initially, it wasn't a problem, but became worse, and she ultimately needed surgery. We made a work cover claim, but the school disputed the dates of the injury. Work cover has denied the claim, and after a conciliation meeting in the city, the insurer flatly refused to take our evidence into consideration and have preferred the false allegations of the school principal. We are deeply offended by these accusations. We are out of pocket thousands of dollars and wish to know whether it is worth persisting with our claim. Thanks. And this is from Brody in Ascot Vale. Now, John, this is quite interesting. They've lodged a work cover claim. The date of injury is in dispute here, and it's gone to conciliation.
Brody, if you believe in your own case, which I think clearly you do, you should see a lawyer to issue court proceedings straight away.
And can I say this too, Kathy? At the conciliation stage, it's not a hearing, and the fact that they've accepted or preferred the false allegations of the principal is irrelevant for the simple fact that there's no allegations made. It's just people throwing things up. It's not tested. It's just someone putting their best foot forward, which is irrelevant, really, because when it gets to court, everything gets tested. Being on yard duty, you'd think there's also a lot of witnesses, being school students and possibly other teachers that were on duty as well. And so I agree with John that if you get advice, it's got some legs, pardon the pun,
Well, Tony, you have to remember that conciliation is a forum for discussion. It's not bound by the actual court. It's the first step, though, before you issue proceedings. And the reason that you do issue proceedings is to go through the discovery process to assist in the claim and hopefully proving these allegations are false.
It's just a system introduced by the government to try and assist in having matters resolved without the need to go to court.
Absolutely.
But for everyone that you've got that resolves, there's a lot that don't.
The problem is, Tony, and there are some people that say that conciliation is also just a mechanism used by the insurer to delay the claim.
I don't know about that. I think it's important that we do have a process because during that process you do collect a lot of information and the insurers are obliged to pay for medical reports. Which also helps because it's very expensive. Doctors are charging a lot of money for reports these days.
Sometimes, John, they do resolve that conciliation. I mean, as I said, it does depend. It is a forum there for discussion and it does help. But with something like this where it's a date of injury that's a possible dispute, it's a little bit more factual and work has to go into it.
And there'll be a circumstances report prepared for conciliation as well. You'd think the employer would get investigators to prepare some sort of a report.
That's right.
We're going to have to...
So we would suggest, Brady, to seek legal advice on that front. But we would like to thank you again for watching and we would like to request you to write more questions to us so we can answer for you at our new email address at info@thepishow.com. Please keep writing in and unfortunately we didn't have time for more questions this evening, but we'll get to them next week. Thank you for watching.
Thanks, John. Thanks,
Thank you,
Kathy.
viewers.
Thank you, Tony.
Thanks, viewers. Stay safe.